Welcome to Middle Class Matters. Today, the 16th June 2023, Business News in English from Dr. CMA MBA Allegation. Report of the Expert Committee constituted by the Honorable Supreme Court of India has submitted the report on Adani issue. This is in continuation of the part number 9. Today we are continuing the part number 10. Para number 47. SEBI has expressed its observations about participating shareholders in the following terms. The economic interest in the above named 12 FPIs, foreign financial institutions, has been held by the PR shareholders, participating shareholders, that is, those with economic interest. Investigation revealed that there were 42 such PR shareholders which are based out of multiple jurisdictions, namely Cayman Islands, Malta, Curacao, British Virgin Islands, Bermuda, Ireland, and United Kingdom. The brief observations regarding PR shareholders are as under. Each of the 42 PR shareholders is incorporated in the form of a company in the above mentioned jurisdictions. Each PR shareholder incorporated as a company in turn has dual shareholding, that is, founder or controlling shareholders, CR shareholders, and economic interest shareholders who in turn have been found to be located across various jurisdictions including tax havens jurisdictions. Details of the POs, beneficiary owners of the CR shareholders of only 24 of the 42 PR shareholders were made available. Details of POs of the remaining CR shareholders and the details of economic interest shareholders of the 42 PR shareholders have not been made available so far. Para number 48. The material on record submitted by the SEBI points to the controlling shareholders of the FPIs and the promoters of the Adani Group respectively, asserting that they are independent of each other. The Adani Group has confirmed on both that no funds have been provided directly or indirectly by them to the FPIs to make investments in the listed Adani stocks. Likewise, it has been stated that the shareholders in control of the FPIs have similarly asserted an absence of connection with Adani and any funding by Adani. Para 49. The entire concern expressed by SEBI, and this precedes the publication of the Hindenburg report, is that SEBI is unable to satisfy itself that the contributors of the funds to the FPIs are not linked to Adani. It appears that bank statements of the 13 entities were made available to SEBI, and indeed bank account details of 42 participating shareholders were obtained. SEBI has been attempting to find out such contributors who have an economic interest in these FPIs. This is where it has hit a wall. It is evident that SEBI had drawn a blank in this investigation, and the publication of the Hindenburg report has revived SEBI's efforts to attempt figuring out economic interest in the FPIs that have these investments in listed Adani stocks. Para 50. It is evident that such an exercise could be a voluminous one, but potentially a journey without a destination. For instance, if SEBI were to get behind a contributing participating shareholder who has given funds to the FPI to invest on its behalf and get to the shareholders of such contributors, it could well be that the contributors could in turn be bodies, corporate, or funds, and there could be multiple classes of shareholders and contributors above that level. The shareholder above could in turn have bodies, corporates above it, and so on, and it would be a humorous task to figure out who the ultimate beneficial owner is. Para 51. What is apparent is that the regulatory framework governing FPIs contains a specific stipulation for compliance with identification and disclosure of beneficial ownership. If such requirements have been complied with. The investigation is about whether the spirit of the law governing minimum public shareholding has been violated by reason of shareholding in the hands of FBIs that are compliant with the letter of law. Para 52. What is also apparent is that SEBI has been investigating the matter since October 23, 2020, whereas the Hindenburg report was published on January 24, 2023, that is 2 years and 3 months later. It is, however, for SEBI to conclude its investigations in accordance with law within a precise time frame. SEBI has made an application to the Honorable Supreme Court seeking extension of time to investigate. The committee is refraining from commenting on this issue. References to other enforcement agencies. Para 53. In its pursuit of investors in the 13 overseas entities, SEBI has also made references on December 10, 2021 to the Central Board of Direct Taxes (CBDT) and to the ED, asking them to investigate for violation of tax law and PMLA respectively. Therefore, the committee called upon these agencies to provide their explanations. Para 54. The response of the CBDT may be summarized as follows. A. SEBI had made a reference to the CBDT on December 10, 2021 on the premise that if it is established that the funds invested in the Adani Group through the FBIs were funds of the Adani Group or its promoters, it may lead to findings of tax evasion. B. Unless a tax evasion petition, that is, the reference from SEBI would be 1. Contains specific, verifiable and actionable intelligence, it cannot be taken up for investigation. C. The tools available to the Income Tax Department to obtain information from overseas tax agencies or the Double Tax Avoidance Agreements DTAA, Tax Information Exchange Agreement TIEA, and Multilateral Convention on Mutual Administrative Assistance in Tax Matters MAAC. D. Of the jurisdictions in which the participating shareholders alluded to by SEBI reside, India has DTAA with 3, TIEA with 3, and an exchange of information relationship with 1. E. An information requesting jurisdiction must clearly establish foreseeable relevance of the information sought for tax purposes and it cannot conduct roving and fishing inquiries. F. Generic requests to foreign jurisdictions are not feasible since this leads to negative comments in the peer review by global agencies and it would impact India's reputation and such requests are not appreciated. G. Recent intrusive searches into listed Indian companies with substantial foreign funding did not show that there was any adverse inference capable of being drawn about such funding as a rampant or endemic feature. Para 55. The response of ED was quite similar to that CBDT and may be summarized as follows. A. SEBI stated that since the issue of tracing of fund flow falls under the domain of money laundering, which is under the purview of ED, the reference was being made. B. ED is not empowered to invoke the provisions of the PMLA without a prior registration of an offence falling within the scope of scheduled offences in the PMLA. SEBI had not filed any case under the scheduled offences listed in the PMLA. C. The ED examined SEBI's reference under the PMLA as well as the Foreign Exchange Management Act 1999 FEMA, but no allegation of contravention of Section 12A of the Securities and Exchange Board of India Act 1992, that is SEBI Act, or any violation of exchange controls has been reported by SEBI. D. The ED has found intelligence about potentially violative and concerted selling by specific parties just ahead of the publication of the Hindenburg report, and this may lead to credible charges of concerted destabilization of the Indian markets, and SEBI ought to be probing such actions under security laws. Para 56. SEBI has also sought information from other securities commissions in other jurisdictions under the Multilateral Memorandum of Understanding MMOU, to which members of the International Organization of Securities Commissions IOSCO are parties. SEBI has submitted to the committee that the IOSCO MMOU requires justification of reasons for seeking information. It appears that SEBI has drawn a blank from regulators in Cayman Islands, Malta, Caracas, British Virgin Islands and Bermuda, without more information, which can only be available after it is provided by these other agencies. It is apparent that SEBI is unable to make out a case for seeking information. SEBI has stated that it is now working on initiating a process of seeking amendments to the IOSCO MMOU in order to get better inputs from overseas regulators in the future. Para 57. In response of the ED and of the CBDT are quite clear and similar in content to the requirements cited under the IOSCO MMOU. Besides, from the plain reading of the Rule 9 of the PMLA rules, it is apparent that there is an incumbent declaration of who the beneficial owners are by each of the FPIs, which could make them compliant with PMLA. Para 58. In a nutshell, SEBI's contention is that it needs information from these other agencies to be able to demonstrate a link to a potential violation. Without such information, SEBI is unable to satisfy itself that its suspicion that has been aroused can be put to rest. The securities market regulator suspects wrongdoing, but also finds compliance with various stipulations in attendant regulations. Therefore, the record reveals a chicken and egg situation. Para 59. It is noteworthy that SEBI, in its legitimate capacity, did away with the prohibition against any FPI having an opaque structure on the premise that declarations of the beneficial owner flows from Rule 9 of the PMLA rules, and that such a stipulation is sufficient for its regulatory purposes. Such compliance having been effected by the FPIs, coupled with the repeal of the provisions on opaque structure, the chicken and egg situation of hoping to get evidence can become a perpetual one. Para 60. Therefore, it appears that the legislative policy stand of the SEBI on the ownership structure of FPIs has moved in one direction, while the enforcement by SEBI is moving in the opposite direction. Para 61. It would be open to SEBI to amend the FPI regulations to stipulate what level of economic interest should be declared by the FPIs in respect of those who own any stipulated proportion of the FPI. These are matters of legislative policy choice. Like the video, give your comments, subscribe to the channel. Thanks for watching.